Number 8. The written contract. Around 5,000 years ago, in a city called Uruk, on the banks of the Euphrates River, a Sumerian merchant pressed a reed stylus into a wet clay tablet and recorded the terms of a business transaction. This was not the first time goods had been exchanged. Trade is older than writing. What was new was the decision to make the agreement permanent, to create a physical record that could be referenced, disputed, and enforced by a third party who had not been present when the deal was made. That tablet, and the thousands like it recovered from Mesopotamian archaeological sites across modern Iraq, represent the first written contracts in human history. They record grain loans, land sales, labor agreements, and commercial partnerships. They include the names of both parties. They include the terms. They include witnesses. And they include penalties for non-compliance. The structure of those clay tablet agreements, the identification of parties, the statement of terms, the conditions of enforcement, the witnesses is identical in its logical architecture to the structure of a contract signed today in any law office, in any country in the world. Every signed agreement you have ever made, every lease, every employment contract, every terms of service, every purchase agreement, they all trace their logical structure to a decision made in Sumerian Uruk roughly 5,000 years ago to make commercial agreements permanent and enforceable by writing them down. The Sumerians did not know they were inventing contract law. They were solving a practical problem. How do you trust someone you have never met with something valuable? They found the answer. The world has been using it ever since. Number 7. Interest on loans. The Sumerians invented the concept of charging interest on borrowed money, not the concept of lending that existed wherever humans lived in communities, but the formalization of a return rate, expressed as a fixed fraction of the principal, due at a specified future date. By approximately 2000 BC, the standard commercial interest rate in Mesopotamia was the equivalent of 20% per year for silver loans and 33% per year for grain loans. These rates were not arbitrary. They were set by custom, regulated by law, and enforced by the same temple institutions that served as the earliest known banking facilities in human history. The Sumerian temples of Ur, Nippur, and Lagash functioned as proto-banks. They accepted deposits of grain and silver, issued loans against those deposits, collected interest at the agreed rate, and maintained detailed written records of every transaction. The temples did not do this out of spiritual generosity. They did it because lending surplus agricultural production at interest was one of the most reliable ways to accumulate institutional wealth. The Code of Ur-Nammu, dated to approximately 2100 BC, and the oldest surviving written legal code in human history, contains specific provisions regulating debt, loan terms, and the conditions under which a debtor could be held in debt bondage. These provisions were not protecting borrowers from a new concept. They were regulating a practice already established enough to require legal oversight. The concept of a percentage interest rate on borrowed money, the foundational mechanism of every modern bank, every mortgage, every credit card, every national debt instrument, is a direct descendant of Sumerian temple lending practices. The Federal Reserve did not invent interest rates. Ur did, approximately 4,000 years earlier. Number 6. The Court of Law. The Sumerians established the first known formal court system. Not a king making arbitrary decisions, a structured institutional process with judges, witnesses, evidence, oral testimony, written records, and the possibility of appeal. The Code of Ur-Nammu, written around 2100 BC, establishes a legal framework built on a specific logical structure. If a defined offense is committed, a defined consequence follows. This if-then structure, the basic architecture of all subsequent legal codes, appears here for the first time in a surviving document. Scholars at the Oriental Institute of the University of Chicago who have studied the code note that this casuistic formulation, as it is technically known, becomes the template for the Code of Hammurabi, which in turn influences Mosaic law, which in turn shapes the legal traditions of Judaism, Christianity, and Islam, which in turn form the ethical and juridical foundation of Western legal systems. The chain runs directly. Sumerian court, Babylonian court, biblical law, Roman law, English common law, modern legal systems worldwide. The Code of Ur-Nammu also introduces something remarkable for its era: financial compensation as an alternative to physical punishment for certain categories of offense. Where later codes, including Hammurabi's famous eye for an eye formulation, demanded bodily retribution, Ur-Nammu frequently specified monetary fines. A man who cut off another man's foot owed 10 shekels of silver. A man who broke another man's bone owed 1 mina. The concept of compensatory damages, paying money to a wronged party rather than submitting to equivalent physical harm, appears here, in a Sumerian legal document, before anywhere else in the surviving record. Compensatory damages are the foundation of civil law. Every lawsuit seeking financial compensation for a harm done traces its logical basis to a legal innovation made in Ur 4,000 years ago. Number 5. The minimum wage. The concept of a legally mandated minimum payment for labor, the idea that there is a floor below which compensation cannot legally fall, regardless of what an employer prefers, appears in Sumerian administrative records from approximately 2300 BC. These records, recovered from sites across the ancient city of Lagash, document state-administered wage schedules for different categories of work. Skilled craftsmen, agricultural laborers, temple workers, and administrative personnel were each assigned specific, minimum daily or monthly grain rations that represented their legally mandated compensation floor. Employers, including the state itself, were not permitted to pay below this schedule. This was not charity. It was economic regulation, driven by the recognition that unregulated labor markets produced social instability. A workforce that could not feed itself from its wages became a social crisis. Standardized minimum compensation was a mechanism for maintaining a functioning labor market. The administrative tablets from Lagash also document something that modern economists would recognize immediately. The minimum wage schedules were periodically adjusted based on prevailing economic conditions. When grain prices rose, the schedules were revised. The concept of an inflation-adjusted minimum wage, the ongoing political debate of virtually every modern democracy, was being practiced by Sumerian administrators in the 3rd millennium BC. The International Labor Organization, the United Nations agency that sets global labor standards, is operating in a tradition that began in a Mesopotamian city-state more than 4,000 years before it was founded. Number 4. Property rights and land ownership. The Sumerians developed the first documented system of formal property rights, the legal concept that an individual or institution can own land, that this ownership can be recorded, transferred, sold, and inherited, and that the state has an obligation to protect this ownership against seizure by others, including the state itself. Sumerian land sale contracts from the early dynastic period, dated to approximately 2400 BC, document property transactions in a form that would be immediately recognizable to any modern conveyancer. The tablets identify the parcel of land by location and boundary markers. They identify the seller and the buyer. They record the purchase price. They list witnesses to the transaction. And crucially, they are signed, or more precisely, sealed with the cylinder seals of all parties, creating an authenticated, permanent record of the transfer of ownership. The concept of a title deed, the document that proves legal ownership of property, derives directly from this practice. When you own a house, and can prove it, with a document recorded in a government registry, you are participating in a system that the Sumerians invented. The Code of Ur-Nammu also establishes protections against wrongful seizure of property. Specific laws address the rights of widows and orphans to retain property left to them. Specific laws address fraudulent land claims. The principle that property ownership is a legally protected right that the state must defend against violation, including violation by powerful parties, appears here for the first time in written law. Every property law, every zoning regulation, every land registry system, every inheritance law, in the modern world, operates on the logical foundation laid by Sumerian legal innovators in the 3rd millennium BC. Number 3. Debt forgiveness. The Sumerians invented something that modern economists call Jubilee debt cancellation, the periodic, state-mandated forgiveness of certain categories of debt to prevent the collapse of the social order under the weight of accumulated financial obligations. Sumerian kings periodically issued decrees called amargi, a word that translates literally as freedom or return to the mother, that canceled personal debts, freed debt slaves, and restored alienated land to its original owners. The earliest known use of the word amargi, found on a tablet from Lagash dating to approximately 2300 BC, is in fact the earliest known use of the concept of freedom in any written document anywhere in the world. The Amargi decrees were not acts of royal generosity. They were pragmatic, economic interventions. When debt accumulated to the point where a significant portion of the population had sold themselves or their family members into debt slavery to pay obligations that continued to compound through interest, the labor market collapsed, agricultural productivity dropped, and social stability deteriorated. The periodic cancellation of consumer debt was a system maintenance mechanism, a controlled release of economic pressure before it became a catastrophic failure. This concept, ancient in Mesopotamia, entered the biblical tradition as the Jubilee year described in Leviticus, the 50-year cycle in which debts were to be canceled and land returned to ancestral owners. From biblical tradition, it entered Western theological and ethical discourse. The modern concept of sovereign debt restructuring, the International Monetary Fund's debt relief programs for developing nations, the periodic political debates about student loan forgiveness, all of them are operating within an ethical and practical framework that was established by Sumerian economic administrators 4,000 years ago. The word freedom was first written in a Sumerian debt cancellation decree. That is not a metaphor. It is the literal archaeological fact. Number 2. Standardized weights and measures. Around 3000 BC, the Sumerian city-states developed a standardized system of weights and measures administered by the state, enforced by law, and applied uniformly across all commercial transactions. The Sumerian system used a sexagesimal base, a mathematical framework built on the number 60 rather than the decimal system's base 10. This was not arbitrary. 60 has more divisors than any smaller number. It divides evenly by 1, 2, 3, 4, 5, 6, 10, 12, 15, 20, and 30, making it exceptionally practical for the kind of fractional calculations required by trade, taxation, and construction. The Sumerian decision to organize measurement around 60 is why today there are 60 seconds in a minute, 60 minutes in an hour, 360 degrees in a circle, and 12 inches in a foot. These are not accidents of history. They are direct inheritances from a mathematical and commercial standardization system developed by Sumerian administrators 5,000 years ago to make trade fair and taxation calculable. The shekel, the unit of weight that became the unit of currency across the ancient Near East and whose name survives today as the currency of Israel, was a Sumerian invention. 1 mina equaled 60 shekels. 1 talent equaled 60 minas. The hierarchical weight system that underlies every subsequent currency system in the ancient world derives from Sumerian commercial standardization. The metric system, the imperial system, the financial systems of every modern nation, they all operate on the principle that standardized, state-enforced units of measurement are necessary for functional commerce. The Sumerians discovered this necessity and solved it. Every time you read a clock, check a compass bearing, or measure an angle, you are using a Sumerian mathematical decision that is 5,000 years old. Number 1. The presumption of innocence. The most consequential legal innovation in human history, the principle that a person accused of a crime is presumed innocent until proven guilty by evidence, appears in Sumerian legal practice approximately 4,000 years before it was formalized in modern legal systems. The Code of Ur-Nammu contains provisions that establish an evidentiary standard for criminal accusations. A person could not be convicted on accusation alone. Witnesses were required. Evidence had to be presented. The burden of establishing guilt rested on the accuser rather than on the accused to establish innocence. In cases where evidence was ambiguous, the accused could demand a trial by ordeal typically involving water. in which drowning was taken as proof of guilt and survival as proof of innocence. But the critical point is that ambiguity resolved in the accused's favor rather than in the accuser's. This is the presumption of innocence. It is not a modern concept. It is not a Western invention. It is not the product of Enlightenment philosophy or English common law. It is a Sumerian legal principle that appears in clay tablets, dated to 2100 BC, predating every other written legal system that contains this protection. The Sixth Amendment to the United States Constitution, which guarantees the right to a fair trial. Article 11 of the Universal Declaration of Human Rights, which enshrines the presumption of innocence as a universal human right. The European Convention on Human Rights. The legal systems of every democratic nation on earth. All of them are elaborations of a principle that a Sumerian king's scribes pressed into clay in ancient Mesopotamia 4,000 years ago. The most fundamental protection you have, if you are ever accused of something, the principle that the state must prove you did it, rather than requiring you to prove you did not, was invented in Sumer. It traveled through Babylonian law, into biblical tradition, through Roman law, into European legal systems, through English common law, into the legal frameworks of every nation that inherited from it. The chain is unbroken. The innovation is Sumerian. You have rights today because of a decision made in Mesopotamia 4,000 years ago. 8 laws, all of them Sumerian, all of them still running. The written contract, interest on loans, the court of law, the minimum wage, property rights, debt forgiveness, standardized weights and measures, the presumption of innocence. None of these appear in the history curriculum as Sumerian inventions. They appear as abstract principles of modern civilization, self-evident, universal, somehow always there. The origin is never mentioned because the origin is inconvenient for the narrative that the modern world is the culmination of a progressive improvement from primitive beginnings. The Sumerians were not primitive. They were solving the same problems every complex society faces: how to make commerce fair, how to protect the weak from the powerful, how to maintain social order without violence. And the solutions they found were so precisely calibrated to the actual problems that 4,000 years of subsequent civilization has not improved on the fundamental structure. They are still running. You are living inside them right now.